Hello, my name is Dr. Daria Sharkova, and today I'm happy to present a new series of educational videos called 3D Arbitration. I will explain why 3D. 3D is three-dimensional, so it calls to something easy and consisting of three elements. I think it's the best for understanding some difficult concept. So today we will start with the definition of arbitration. Arbitration is often perceived as cheap or cheaper, less time-consuming, more confidential, and the award is easier to enforce as a decision than a decision. But what is arbitration? Do we really know what it is? Does it mean something when the parties put in their contracts that they submit their dispute to arbitration, or it's just a label? Well, label is not always decisive, so you should always examine the provision to determine whether it constitutes an agreement to arbitrate or do something else. But the district court of the U.S. District Court in Benson Pump versus South Central Pool Supply said no magic words such as arbitrate are required to obtain the benefits of the Federal Arbitration Act. If the parties have agreed to submit a dispute for a decision by a third party, they have agreed to arbitration. Okay, so it seems like common law and civil law scholars agree on the meaning of the term of arbitration. For instance, Alan Redfern and Martin Hunter said that arbitration is when two or more parties are faced with a dispute which they cannot resolve themselves and agree that some private individual will resolve it for them, and if the arbitration runs its full course, it will not be settled by a compromise, but by decision. René David, which was representative of the French arbitration school, said that arbitration is a device whereby the settlement of a question which is of interest for two or more persons is entrusted to one or more other persons, the arbitrator or arbitrators, who derive their powers from a private agreement, not from the authorities of a state, and who are to proceed and decide the case on the basis of such an agreement. So we can see that there are three main characteristics of arbitration. First, it's resolution of a dispute. Second, its contractual nature, there should be an agreement to arbitrate. And third, there should be a binding decision. First element, the resolution of a dispute, is basically the distinction between dispute and being resolved and some other solutions, for instance, negotiations or advisory recommendations or even the mediation, because these means don't really resolve the dispute, right? The parties have the right to refuse this decision. And for instance, Article 1496 of the French Code of Civil Procedure is explicit, stating that arbitrators shall resolve the dispute, right? The second characteristic is the contractual nature. Arbitration is a consensual means of resolving dispute. So the decision maker, the arbitrator, whatever he's called or he or she is called, is selected by the parties. By the contrast, if the parties agree to entrust dispute resolution to arbitrators, they enter into a contract, right? And even Article 2 of New York Convention or Article 8 of Ancestral Model Law talk about the agreement of the parties. And the final third element of today's short video is the binding decision. So the main and the most important characteristic of arbitration is the binding character. So the decision, the arbitral decision, is a final decision, which is subject only to limited grounds for challenge and is also underpinned by an international system of recognition and enforcement of arbitral awards by local courts. So decision can be always coercively enforced against the parties if they don't want to comply. Well, it's all for today, and this video will be on my YouTube channel, so I hope to see you soon.